Rossi Alston Jr., the Honorable Liam O'Grady, the Honorable Stanley Klein. Oyez, oyez, oyez. All persons having any manner or form of business before this United States District Court for the Eastern District of Virginia are admonished to draw nigh, give their attention, and they shall be heard. God save these United States and this honorable court. Please be seated and come to order.
Well, good afternoon. We'll now have a case of Stevens versus Tweedery argued. Ms. D'Agostino?
Yes, Your Honor.
Whenever you're ready.
May it please the Court, my name is Laura D'Agostino, and I represent the plaintiff, Randall Stevens. May I reserve 2 minutes of my time for rebuttal?
Yes, you may.
Your Honors, Randall Stevens is entitled to summary judgment because there is no genuine issue of material fact in this case. Therefore, the plaintiff respectfully requests this Court to grant his motion for summary judgment for the following 3 reasons. First, Randall Stevens is a qualified individual under the ADA. Second, Tweedery Promotions unlawfully discriminated against Randall Stevens in the workplace. And third, Tweedery Promotions is a covered employer under the ADA. Now,
what do you rely on for your coverage purposes? Are you relying on the 20th employee, or are you relying on the students, 3 students who were working during 2012?
Well, Your Honor, I'm relying on the standard established in the ADA and under Walters v. Metropolitan of the minimum of 15 employees for 20 working weeks of the year, and on the 3 college students that are not listed on the payroll.
Well, that's kind of my question. Are you relying on that 15th employee who didn't make the final half of the week to qualify, or on the 3 students as being employees instead of independent contractors?
Yes, Your Honor. I am not relying on Mr. Marble that was terminated midweek. I'm relying on the 3 college students. As I will show, they are employees of Tweedery Promotions.
So you're conceding the issue of that particular employee, 1/2 week too little. You're conceding that that is not a violation.
Yes, Your Honor.
Okay.
An employee that's terminated midweek cannot count towards the minimum. Now, as was articulated in Roberts v. County of Fairfax and in EEOC versus Baltimore Medical Center, a qualified individual is one who, with or without reasonable accommodation, can perform the substantial duties of his work. Randall Stevens clearly meets this standard both prior and after the Penguin incident. If you take a look at Exhibit 4, Randall Stevens passed his physical and mental evaluation with flying colors. Additionally, in Exhibit 5, it shows that on numerous occasions, he was able to secure not only some of the most difficult clients in the industry, but he also was able to secure more clients on numerous occasions than the other sales associates. Additionally, even though he was transferred to the accounting department in November and all of his clients were reassigned for the end of November and December, he still had the highest overall percentage of securing clients for the year of 2012. Additionally, in an email that J.D. Hogg sent to Mr. Duke, he spoke of great praises of my client, saying that he had set not only unprecedented records at Tweedery Promotions, but also he had numbers that are generally not seen in the industry itself.
What was his recent performance, though?
The last on record, Your Honor, is for the November month, which he had secured 2 clients. However, keep in mind that he was transferred to the accounting department on November 20th, so there was still a window for him to perform in. Doesn't
the record bear out that there was some difficulties with maintaining and sustaining this client because of his actions and performance with regard to selling the wares that he was responsible for selling?
Well, Your Honor, the only negative performance against my client are 2 unsatisfactory client complaints that J.D. Hogg received.
And those were the 2 most recent situations or circumstances that he had in the workplace, weren't they?
Yes, Your Honor. However, there's a distinction between an individual that cannot perform his job duties whatsoever and an individual that perhaps performed them at a lesser level compared to his previous superior performance. Take into account Harris v. Reston Hospital Center. In that case, you have a registered nurse that was clinically diagnosed with depression, attempted suicide multiple times, forgot about her patients, gave the wrong dosage of medication. That's a case of an individual that cannot do their work whatsoever. My client instead had just a month that he secured fewer numbers of clients, but there's nothing on record to indicate that had he been allowed to retain his position of sales associate, that he could have secured the additional clients he usually.
How long does an employer have to wait when he gets news like this from two most recent potential customers?
Well, Your Honor, there's nothing in the common law that really imposes, and the employer is given pretty broad discretion. Even the day of, the employer can take action. However, Tweetery Promotions' actions raise a reasonable inference of discrimination. As is articulated in Heiko v. Colombo, once a plaintiff has made a prima facie case of discrimination, the burden then shifts to the employer to articulate a legitimate, non-discriminatory reason for the adverse employment actions. And it's clear that in this case, Tweetery Promotions cannot do that. First, in an email that J.D. Hogg sent to another employee, he referred to my client as, quote, the mental patient, and, quote, one who needs professional help. These comments are not only incredibly unprofessional, but they severely ruined my client's work environment and the respect that other employees have for him.
So you would maintain in this court that dressing up in a penguin outfit is not something unusual or something that might draw attention to yourself in the workplace?
Your Honor, while that is eccentric and in itself also not professional, that in no way bears on his ability to perform his duties.
Where does eccentricity begin and depressed conduct start?
I'm sorry, Your Honor, could you repeat the question?
Where is something eccentric? When does it leak over to being something that's not conduct that you're going to want to have in the workplace?
Certainly, Your Honor. Perhaps if he had gone and met the other clients in a penguin outfit or consistently worn it, he wore it specifically just on the day when his ex-girlfriend was there to try to win back her affections. No other clients were present, and in no way did it ruin Tweetery Promotions' reputation.
But there was an indication here that the new client that was being pursued had some sort of penguin reference in the context of its circumstances. And so wouldn't there be a concern on the part of the employer that if we had an employee who would like to dress up in penguin outfits, that this contract might be compromised to some degree?
Well, Your Honor, not in this case. The fact that J.D. Hogg didn't let my client handle that account further shows an inference of discrimination. Now, in this case, Randall Stevens was transferred to the accounting department after only 2 negative reports. If we look at the record, there are other sales associates that perform near or slightly above his load, yet they were allowed to retain their capacities as sales associates. They were not reprimanded. They were allowed to retain all the full benefits.
How do you deal with the Exhibit 8, which is the CEO's letter of February 7th of 2012, where he is suggesting that Mr. Stevens be made vice president, and he's asking really Mr. Duke to look at it independently because he says, I'm close to the kids, so I want an objective opinion on something. How do you feel about him being promoted to the position? And so there he's demonstrating great favor with Mr. Stevens. So how do you deal with that?
Yes, Your Honor, and that kind of relationship further demonstrates how drastic the discrimination occurred. Almost overnight, Randall Stevens went from enjoying a relationship like that with J.D. Hogg to J.D. Hogg would no longer meet with him without a secretary present. The secretary would always take notes. As was mentioned by Your Honor, when there was a potential client, he was kept off because, quote, he was afraid it might trigger another crazy outburst. These are all things that show the drastic change in the relationship that occurred, and one that Randall Stevens was subjected to unlawful discrimination.
Are you asking us to make factual determinations in support of your motion?
No, Your Honor. There is no genuine issue of material fact here. This is merely about the law.
You are urging us to establish a pretty broad test, liberal test, as far as the scope of what constitutes being able to perform essential functions, aren't you?
Not exactly, Your Honor. If we also look at the standard of Chamberlain v. Valley Health System, that's another great example that can shed further light on this ambiguity. In that case, you have an individual that's very much like Randall Stevens. She had developed a slight defect in her right eye. However, she had that corrected and then was able to resume her normal work functions, even though she had a period of limited ability. However, she was given the cold shoulder by her company, even though her doctor authorized her to go back to work. In that case, that's an example of a qualified individual that is given the cold shoulder by the employer because of a discriminatory motive. Now, in Vera v. Rose, in that case, there's a very important and clear standard that allows us to examine the issue further. In that case, the court elaborates that an employee's disability need not be the sole cause of the employment action against him. It need only be a motivating factor. So in this case, the defendant might try to argue that his lower numbers for the month of November, that was the reason why he was transferred to a department that he had no prior experience in. However, given the fact that J.D. Hogg made those comments about my client, given the fact that other individuals who performed very poorly in the company were not reprimanded, these all raise an inference that discrimination was the motivating factor against the actions taken against my client.
Let me ask you a public policy question related to this. If we accept the test that you want us to utilize on this third problem, aren't we going to be discouraging employers from hiring people with disabilities because they might find themselves in the same position this defendant finds itself? Right now, the people who are coming back from Afghanistan, wounded warriors, who we all should be trying to help get jobs, wouldn't we be discouraging those who come back with some degree of disability, whether physical or mental? Wouldn't we be discouraging employers from hiring them?
Well, Your Honor, I would argue the opposite. By imposing these standards on the employer, you ensure that these individuals are not discriminated against. You can ensure that small businesses don't hide under the law and treat these people without respect. And in fact, in Young v. UPS, in that case, it was more about accommodation, so it's slightly different from ours. However, the court mentions that the ADA does advise an employer that when he has an employee with a disability, to kind of initiate an open, interactive process with him to determine the best accommodation for him. Now, granted, our case is not about accommodation, but Tweetery Promotions did nothing to consult with my client. They didn't tell him about their concern about his numbers. They merely transferred him to another department, they saw him as a liability and a problem, and they put him in a position that he would leave himself.
Counsel, wouldn't another argument or a suggestion to Judge Klein's question be that there is no need to establish any public policy determination here, but rather we have nuanced facts which justify the result that you're claiming?
Your Honor, it honestly seems to support both propositions. Imposing this standard on an employer is an effective public policy. It ensures that some of the most vulnerable victims of our society can be ensured to an equal employment opportunity. And then on the other hand, it also ensures that the law is being met, it is being upheld in this case. Now, Tweetery Promotions is also a covered employer under the ADA. And this is imperative because if the employer does not meet the standard, this case falls apart. Now, as Walters v. Metropolitan articulated, a covered employer is one that has a minimum of 15 employees for 20 or more weeks in the current or preceding year. And Justice Scalia articulated in that case that while the payroll test is the primary test one utilizes to determine how many employees an employer has, one must also look to see if there's a substantial employer-employee relationship. In this case, the 3 college students clearly have that standard with Tweetery Promotions. First, they provided substantial services to Tweetery. Additionally, they cannot be considered independent contractors. They are employees. As is discussed in Nationwide Mutual, in that case, there is great ambiguity in the common law about defining an employee. There's no magical test, there's no clear-cut standard, there are a variety of different factors one looks at. I see that my time has expired. May I briefly conclude?
Yes, you may.
Even if there's that ambiguity in the common law, the fact is, in the case of Silichek v. Innova Health Systems, one cannot ignore the party's intent to establish an independent contractor relationship. The evidence at hand clearly shows there's no such intent. Thank you.
All right. Thank you, Ms. Atkinson. Ms. Mackley, whenever you're ready.
afternoon, Your Honors. May it please the Court. My name is Lucy Meckley, and I represent the defendant, Tweetery Promotions. May I reserve 2 minutes of my time for a vote?
Cross motions, yes, you may.
Yes, thank you. Your Honors, this case is really about preventing the misuse of the ADA in order to protect a small business's right to make reasonable employment decisions and thereby sustain itself. Both parties have stipulated the material facts of this case. Your Honors, we are not here today to dispute those. However, as a matter of law, defendant is entitled to summary judgment for the following 3 reasons. First, Tweetery is not a covered employer as defined by under the ADA because it did not have 15 or more employees for more than 20 weeks in the 2011.
Counsel, in the context of this case, you claim there's stipulation that there's no genuine issue of material fact, which is obviously the summary judgment standard. But on the one hand, I hear you saying that there are not enough employees to cover it under the Act, and your colleague opponent says that there are. How is that issue going to be resolved in the context of what we have to do? Because someone ultimately needs to make a factual determination.
That is correct, Your Honor. After explaining how the university students are independent contractors, you will see that the fact is not in dispute.
So are you suggesting to this Court that it is a question of fact or a question of law as to how we resolve that?
It is a question of law, Your Honor, because the employees, or the individuals, the university student individuals, do not count towards 15 employee minimum, and therefore the ADA does not apply to this case.
So I'm assuming that in the context of your argument, you're accepting the concession made by your opponent colleague that the employee who had been let go would not qualify for an employee for us to consider to come up with the requisite number of employees under the Act.
That is correct, Your Honor. The second reason that the defendant is entitled to summary judgment is that the plaintiff has not shown that at the time he was reassigned, he is a qualified individual because he could not perform the essential function of his job as a sales agent.
What responsibility does the company have to address mental health issues that are found in Mr. Stevens in a proactive way versus in minimizing his contact with customers by moving into the accounting department?
Your Honor, under the ADA, if a reasonable combination can be made without undue burden on the employer, then that must be given before employment action can be taken to see if the individual can still perform the essential function of his job.
Well, they didn't really afford him anything, did they? We've got a few years before the medical exam, he's fine physically and mentally. He is knocking the ball out of the park every month until someone says that she doesn't want to marry him, and he finds himself in a difficult situation, and he agrees he was terribly depressed. It's 1 month later when this all starts. Aren't you asking us to ignore all of the good time, all of those years, and just allow your client to focus on something that went on for, I think, 32 days?
No, Your Honor. The reassignment was temporary. His reassignment to accounting, it was temporary. However, also, if you look at Exhibit 10, 2012 monthly sales statistics that show the number of clients approved by each salesperson per month, the decline began in August. However, the decline was not significant in August. In August, he was able to gain 12 clients. In September, he was able to gain 11. In October, he gained 8. In November, almost the entire month, minus about a week and a half, he gained 2. This is an unprecedented decline in performance. Looking at the other sales associates, you do not see the same sort of decline. Tweetery is a small business, and therefore, based on that decline in sales performance, in addition to the feedback given by 2 large accounts that gave as their sole reason for not working with Tweetery the plaintiff's lack of enthusiasm and poor representation of the company, the Tweetery had to make the best decision it could in order to sustain itself.
So we ignore the fact that he still had twice as many sales as several of the other employees at the end of the year, and that he was successful in enrolling the highest percentage, almost 75% of the potential customers he was given each month, higher than anybody else?
No, Your Honor. Those facts are in the record. Those are stipulated.
However, 2 main points I want to make on rebuttal. The first with respect to the burden shifting test, and the second with respect to the independent contractor. With respect to the burden shifting test, even if this court finds that the defendant has articulated a legitimate non-discriminatory reason for the adverse employment actions, it is only a pretext for discrimination. Given J.D. Hogg's comments against Randall Stevens, given the fact that all of his clients were reassigned to people with less experience, and so forth. Additionally, with respect to the independent contractor test, if one looks at the NLRB case once more, they specify further what the duties of an independent contractor are. The court there says that an independent contractor has some kind of authoritative decision.
The standard to judge independent contractor status pursuant to the National Labor Relations Act is different from the standard that we use to decide whether or not someone meets the standard under this act, isn't it?
Yes, Your Honor, there is that slight distinction. However, given the ambiguity in the common law, that standard in that case provides the greatest level of foresight and ability to make a decision.
The decision of the National Labor Relations Act is an agency determination, which obviously is considered in a different context than if we were to come up with a court determination.
Yes, Your Honor, that is true. However, that case is very demonstrative in its analysis. If you typically look at independent contractors, many of them have usually their own business, and they have sort of the authority to kind of make their own shots. Now, while these 3 college students had flexibility in their relationship with Tweetery Promotions, there's nothing on record to indicate that Tweetery had an intent to classify them as independent contractors. In fact, in the previous case where there was a doctor classified as an independent contractor, he is actually identified both by himself and his employer as an independent contractor.
Let me ask you about the same thing. The off-books pay, how does that fit into the equation?
Your Honor, I see my time is briefly concluded. May I answer your question?
Sure.
Certainly. The fact that these 3 individuals are kept off the books, Your Honor, is a broader policy decision. Injustice occurs whether it is performed by a big corporation or a small corporation. Keeping these individuals off the books suggests an intent to not be covered by this great law. For the foregoing reasons, this court should grant my client's motion for summary judgment. Thank you.
Thank you. All right, Mr. Mackley, 2 minutes.
Just 2 points, Your Honors, briefly addressing what opposing counsel has already mentioned. In terms of the burden of production being met, opposing counsel mentioned that that was merely pretext. However, in the case St. Mary v. Hicks, the court ruled that not only must pretext be shown, but the plaintiff must show that not only must the plaintiff show the offered reason is false, but they also must show that discrimination was the real reason. That burden has not been met, Your Honors. Second, opposing counsel has mentioned that the intent of both Tweetery and the university students was for an employment relationship to exist. However, as the court in Garrett stated, the overall circumstances of the relationship between the individuals and the company are indicative of the intent. The overall circumstances that have previously been mentioned show the intent was not for an employment relationship to exist. The students possibly did not have their own business because they were university students. They were focused on school. However, they were doing these jobs independently. They were able to take them or leave them at will. Any of Tweetery's 14 employees on the payroll do not have the same liberties. Therefore, those students should not be counted toward the 15-employee minimum. Thank you.
Thank you. All right, we'll recess the court at this time and deliberate.
All rise.